Estate tax exemption sunset 2026. The year 2026 marks a significant shift in estate planning for New York residents. This change stems from the expiration of key provisions in the Tax Cuts and Jobs Act, TCJA, of 2017, which temporarily increased the federal estate tax exemption. As these provisions sunset, the exemption will return to pre-2018 levels, creating potential tax obligations for estates previously unaffected. It's crucial for individuals in New York to reassess their estate plans to adapt to these changes. Understanding the legalities of the 2026 estate tax changes as 2026 approaches, New Yorkers must navigate the legal implications of the reduced federal estate tax exemption. The TCJA had doubled the exemption from $5.49 million in 2017 to $11.18 million in 2018, with adjustments for inflation. However, in 2026, the exemption is set to revert to its original level, adjusted for inflation. This reversion will likely increase the number of estates subject to federal estate taxes. Additionally, New York's estate tax laws add another layer of complexity, as the state's exemption is lower than the federal threshold, currently at $6,940,000 for 2024. Estates exceeding this threshold are subject to New York's estate tax, which ranges from 3% to 16%, depending on the estate size. Given these impending changes, it is essential to consult with an attorney to ensure that your estate plan remains compliant with both state and federal laws. What the 2026 estate tax exemption sunset means for you when the federal estate tax exemption decreases in 2026. Many estates that previously fell below the taxable threshold will face substantial tax liabilities. This change necessitates proactive planning. New York residents, in particular, should be aware of the state's estate tax cliff. If an estate exceeds 105% of the state exemption amount, estimated at $7,287,000 for 2024, the entire estate, not just the amount over the exemption, is subject to state estate tax. This could result in a significant tax burden for estates that slightly exceed the threshold. Consulting with a lawyer to review and possibly adjust your estate planning strategies before 2026 is critical to minimizing potential tax exposure. Key steps in adjusting your estate planning process adapting to the upcoming changes involve several strategic actions. Reviewing estate plans. Given the shifting landscape, a thorough review of your estate plan is necessary. Ensure that it aligns with the reduced federal exemption and New York-specific tax regulations. Utilizing gifting strategies. To reduce the size of your taxable estate, consider making lifetime gifts. By taking advantage of the annual gift tax exclusion, you can transfer assets to your beneficiaries without incurring federal gift tax, thus lowering your estate's value before the 2026 changes. Incorporating trusts. Trusts, such as bypass trusts or irrevocable life insurance trusts, ILITs, can be instrumental in protecting assets from estate taxes. These legal instruments can help manage your estate's tax liability and ensure your beneficiaries receive the intended inheritance. Periodic estate reviews. Regular reviews of your estate plan with an attorney ensure that it remains effective under the latest tax laws. Adjustments may be necessary as new regulations come into effect or as your personal circumstances change. As the 2026 estate tax exemption sunset draws closer, it is vital to work with a law firm that understands the intricacies of both federal and New York estate tax laws. At Schlessel Law PLLC, located at 34 Willis Avenue, Suite 300, Mineola, New York, 11501, our team of experienced attorneys is ready to assist you in navigating these changes. Don't wait until it's too late. Contact us today at 516-574-9630 to secure your estate's future and protect your family's financial well-being.